Welcome to All Things Financial with Jack Driscoll. Each week, Jack takes on all things you thought were hard to understand about your finances and makes it fun, easy, but most of all interesting. From insurance to the best way to save your money and squeeze the most out of the dollars you put aside for your rainy day. And now, you have a friend in the money business. Here's your host, Jack Driscoll.
Welcome back again, everyone, to another edition of All Things Financial. As you know, I do this show often to try to promote in the community a lot of the areas and issues regarding financial planning and all things financial, actually, that you may be aware of or may not be aware of or may have heard some things about and not sure exactly what they mean. So I thank you again for tuning in, those of you on the radio and watching on TV. Today we have a return guest back again, Tammy Singleton-English. Thank you very much for coming back.
Nice to see you again.
Tammy is an attorney and a CPA who's helped in the financial community with many different issues, and Tammy's come back. Tammy, today you're back, I think, to help with some areas in what?
I thought we would talk about powers of attorney, living wills, a little bit about guardianships, and sometimes the use of trusts.
Okay, so sometimes we run into, even on the financial side, we're not allowed to answer questions when we run into with our clients. What do we do with this? How do we list different names, or what do we do? Do we have a will or do we need? So Tammy, I'll turn it over to you if you want to maybe help explain what some of these, I guess they're called ancillary documents that people need to think about and things like that.
Right. Well, one thing that's very important for people is powers of attorney. A lot of individuals realize that they need to have a will, but, and you might know this better than I do, the statistics on the possibility of being disabled are 4 times as likely as death.
Correct.
Is what I've been told, which means that you have 4 times more likelihood to need a power of attorney than to need a will.
Okay.
Statistically.
I had not looked at it that way. I hadn't.
And with the powers of attorney, really what it means is that if you are incapacitated either temporarily or permanently and you need someone to make decisions on your behalf, that with that document they are legally authorized to act on your behalf. Sometimes people will say, oh, well, my husband or my wife or my children, they'll take care of things. I don't need a power of attorney. And usually what I tell people is that you should name your husband or your wife or your children as your agent under your power of attorney, because there are instances when a financial institution or a medical facility will not take the advice of that individual if they don't have a written document authorizing it.
Okay.
And usually it's not that the bank, for say, wants to cause problems, but they don't want to get into any legal issues later if they listen to somebody who was not authorized to act on behalf of their client.
Yeah,
So,
they could get in trouble.
Right, they could get sued later, because if, for instance, if I don't have a power of attorney and you're my husband and you go into the bank and say, oh, I'm going to take out all this money, she's my wife, we're going on a trip or something, and then my children come along later and say, well, why did you give him all that money? His name wasn't on the account. Mm-hmm. And so they don't want to get into the middle of that. And that's why the institutions sometimes will not act unless there is a power of attorney.
Okay.
And then there are different types. What I generally tell people is there's a durable general power of attorney, which essentially is for finances. There's a healthcare power of attorney, which is for health-related matters, and then there's a living will. So with the durable general power of attorney, that allows the person who executes that document is called the principal, and the person that they designate to act on their behalf is called the agent. So on the durable general power of attorney, the principal is authorizing the agent to take care of any financial areas of his or her life. So that could be things like paying your bills, filing your taxes, selling stock if the market's going up or down or something is happening, if you need to sell a house. All of those things are things that are covered under the durable general power of attorney,
Okay.
which we refer to that as the financial one. The other one is the healthcare power of attorney, which again, if the principal is not able to act on his or her own behalf, then the agent can act for him or her. That entitles the agent to work with the doctors at the hospital, enroll somebody in a home nursing facility or a nursing care or home care, or deal with the health insurance benefits, deal with the drugstore. I mean, anything really related to your medical health needs. So oftentimes my clients will name the same individual as agent under both of those documents, but I also have times when people want a different person,
Okay.
particularly with the financial versus the healthcare. If you have someone in your family who's a nurse, well, they'd be great on the healthcare power of
Right.
attorney, but if that person doesn't know how to balance a checkbook, then you might not want that person on your financial power of attorney. So it's a good alternative, and it allows people the flexibility to do different individuals in the different capacities.
They sound important. I didn't realize the importance, especially of the power of attorney. I didn't think about when you're dealing with a situation where somebody's disabled
Right,
and those facts that you bring up.
right,
We've always thought, yes, the likelihood is much greater, but I've never stretched it over to the legal side.
right.
This, folks, is why you need to deal with financial planners and attorneys and accountants, not just relying on one professional. This is why we each don't know all of everything, but in combination, if you surround yourselves with the best of each category, then you do have a team that knows the best for your situation in all of these categories. Don't you agree with that?
I definitely agree. Now, the other aspect of the power of attorney is the living will, which is different than a will. When people talk about a will, that's the document that disposes of your assets upon your death. The living will is if you are in a terminal illness or a permanent state of unconsciousness and you don't want to be kept alive on machines, then you need to have a living will document, and it has to be drafted and signed before you become terminally ill or in a mentally incapacitated state. And what it does is it's under state law, and I believe every state in the country now has those. It didn't used to be the case that every state had them, but I believe every state does now. And the person who executes that document, essentially what they're saying is that if I become terminally ill or in a permanent state of unconsciousness, I am telling you right now that I do or do not want these various treatment options.
Okay.
And there's kind of a blanket form where it says, I don't want anything. I don't want to be kept alive. I don't want dialysis. I don't want this. I don't want that. I don't want amputation. I don't want this whole list of items. We usually do include pain relief because we don't want the person to be suffering. So we do encourage pain relief. But other than that, there's nothing to prolong life. That's an instance where the medical community is as certain as they become that the patient is not going to recover, and that we're talking about a matter of hours, days, weeks, and then it becomes a question of, well, how much do you want to prolong this because there's no chance of recovery? So that's the living will. You can have a surrogate, which is the person who makes the decision on your behalf, or you can just say, no, I want the doctors to determine this.
Okay.
And when my clients come into the office and they ask, why would I want one or the other? And I tell them that it's probably a 50-50 split. The people that I deal with, half of the people want to have a surrogate and half of the people don't want a surrogate. They just want the doctors to decide. The surrogate would be, again, anybody that you choose that you feel comfortable making that decision. So your spouse or your children or your parents or your sister or whoever it is. The reason people sometimes do not want a surrogate is that they do not want to put that level of guilt on that person for making that decision.
Okay.
They would rather just say, if I'm in this condition and I have had 2 doctors that have agreed that that's the condition that I'm in and there's no chance of recovery, then the doctors are going to follow the terms of this agreement.
Okay.
rather than making your spouse or your child second guess themselves. Did I do the right thing? Did I make the right decision?
Okay.
So that's kind of the difference between having it with a surrogate and without a surrogate.
Okay.
And then on the powers of attorney, to flip back to that for a second, they can become effective immediately when they are signed, or they can spring into action when the principal becomes incapacitated.
Okay.
So there's two different. So there's a healthcare and a financial, and then there's effective immediately, and there's springing. So essentially, there are 4 different types of documents there.
Okay.
And the difference with that is that a lot of people hear these stories of, oh, I don't trust them. They're going to kick me out of my house. I can't sign this power of attorney because they'll kick me out of my house, and then I won't have any place to live. And one thing is, if you have a springing power of attorney, no one can take over for you until they have doctors certifying that the principal does not have mental capacity.
Okay.
So if somebody is really fearful that their children or their relatives are going to kick them out of their house or steal all their money for them, for one, maybe you want to find a different agent. That's the first choice. And 2, you would have it be a springing document where, as long as you have mental capacity, you are in control of all of your affairs, both your financial affairs and your health care. And only upon your inability to function does somebody else come in and take over for you.
Okay.
The other thing that I can tell people is that the agent is in a fiduciary relationship, which means that the court is watching you. I mean, you don't really have to report to court, but you have a legal obligation to act in the best interest of the principal, not the agent.
Okay.
So again, the person who creates the document and gives that power away, that's the principal. So the person who's acting on their behalf is required by law to do what's best for the principal, even if it's adverse to the personal interests of the agent.
Okay.
And again, there are instances where people take advantage of situations, and you read about things in the newspaper.
Yeah.
Those people are committing a crime. I mean, that is a breach of fiduciary duty, and they are not legally authorized to act in that behalf. So it's no different than breaking into a convenience store and stealing money out of the cash register. It's a crime. Mm-hmm. So that's kind of what those documents provide, and they're a good foundation for people, and I really encourage everybody to have one. It doesn't matter how old or young or healthy or sick you are, because we can't predict the future, and if you are in a car accident today, you might have just a broken bone and be fine, or you could be mentally unable to make decisions for several months, or it's hard to know what the future holds.
Yeah.
So
have you seen cases where either banking institutions or financial institutions or hospitals or doctors have said, your power of attorney is too old, or we won't accept that, we only accept ours?
Sometimes, yes. With financial institutions, especially the larger financial institutions, they want to use their own form. That's not to say that there's something wrong with a different form, it's just that their legal department has authorized them to use that form. They're comfortable with it, they've seen it before, they know when they see that come across their desk that they're allowed to do what it says. So it's not that there's something wrong with the other power of attorney, it's just that they have that comfort level and they've been authorized internally to use that form.
So what's your recommendation to people to do the general paperwork,
right,
and also contact their most frequently used doctors and
yes,
banks
right,
and
right.
things like
And oftentimes with the doctors, I encourage people to give the doctor a copy of the living will and the healthcare power of attorney, so that
Okay.
they have the copy in their file. And the same thing with the bank. If you have a very frequent relationship with a bank or a financial advisor, and you want that person or that institution to have a copy of your power of attorney, then by all means, they can make a copy and put it in the file. And
almost
then
get it cleared in
right,
advance.
then they know in advance that, oh, okay, well, if something happens to my client, Mr. Smith, then his daughter who lives in Texas is going to take over, and I have the paperwork right here to show me that that's going to be the case.
Okay.
So it's a good way to do it.
Good.
As for them not wanting to follow the terms of the document or saying that it's too old. In Pennsylvania, there is a statement on the back of the power of attorney where the agent has to sign it and date it, and essentially the agent is saying, yes, I agree to act as agent under this power of attorney, and I agree to act in the best interest of the principal. Okay. That piece of paper, sometimes banks more than anybody else will say that's too old. So that's an easy fix because you just have that agent sign and date it again. That's all they have to. The agent, not the principal. The principal's document never gets to be, it never gets to be too old. There's no such thing as a power of attorney that's too old because the principal signed it 5 years ago or 10 years ago or 20 years ago. Okay. It was effective under law at that time, and those are grandfathered in, and so they will always be effective, assuming that you executed it correctly, okay. Which is another reason why it's not always the best solution to just go to the office supply store and get some form document that you find on the shelf or on a computer program, because in addition to the words on the paper, it has to be completely executed according to Pennsylvania requirements.
Okay.
So, but they're good documents to have. They can be very useful, and a lot of people maybe don't use them. I tell people it's like Murphy's Law. If you have one, you'll probably never need it. Right. Sure enough, you don't have one, and that's what happens, and you should have had it. Because if you don't have a power of attorney and somebody becomes incapacitated, your only choice is to get a guardianship, which is a very time-consuming, expensive procedure. It involves going to court. You have to take the ward to the court. The ward is the incapacitated person. You have to take the person who wants to serve as guardian. That person has to go to court. You have to present your case before the judge. The judge has to approve it or not approve it. If the person is approved to serve as the guardian, they have annual reports that they have to file with the court. They have to ask for approval before they're allowed to spend any money.
Wow.
They're not allowed to spend the ward's money. They spend their own money. Then they ask for reimbursement through the court.
Wow.
Yeah, a guardianship is not a good solution. It's a better solution than nothing, but that's why I think it's very important to execute the powers of attorney, because that prevents you from having to go through the guardianship process.
Okay. That doesn't sound like good
no.
planning at all. Lack of planning.
That's essentially what that is, lack of planning. Yeah, it's one of those where, oh, I meant to get to it and I forgot, or I went on vacation and then something else happened, and then you have a problem, and then you end up with the guardianship. And as I said, it's a better solution than nothing, because then there is somebody who can act on the behalf of the incapacitated person, but it's a big burden on that guardian, and a lot of attorneys won't work with those because the court system is very not consumer friendly when it comes to guardianships. And so you have limited access to people who really know how to get involved with the guardianship proceeding.
Okay. What do we do in a situation where you have someone younger, that might either inherit what you have or whatever? What do we do in those cases?
Oh, okay. So with young children, so in Pennsylvania, under the age of 18 is considered to be a minor. And some people think that they'll just give all of their assets to their spouse or to their children. And that's very common. I mean, that's what most people do. If the person dies at a young age and has young children, then you have a whole different situation that you have to deal with, because this is a state-by-state kind of procedure, and even within the state, each county can implement these rules a little bit differently. But the rule essentially is that if somebody is under the age of 18, under the age of majority, so that they're a minor, and they're supposed to inherit an asset, what the court requires is that the asset is liquidated and the cash is put into a sequestered bank account. Now, a sequestered bank account is a very specific type of bank account. it's essentially like a passbook savings account. So it's only earning interest. That's it. And the interest is
on cash.
0.5%. And it's on cash. And the cash will sit there until the child reaches the age of 21.
You're kidding.
No.
So in Pennsylvania, we have stocks and bonds.
Right. They're all sold.
We distribute through the will,
Right.
if that's how we did it.
Right.
We want all the grandchildren and children to receive those
Right.
and continue owning those.
Right.
And because they're a minor, the courts won't allow it. They'll
Right.
trump that
Yes.
decision and force liquidation, force income taxation,
Right.
and force holding his cash for 18 more years or however long it is.
Exactly.
That's horrible.
I know. The court's position is that they are protecting the assets from either unscrupulous scam artists that come along and try to take advantage of you, or speculative kind of investments. And so it's essentially that the court is forcing you to put the money under the mattress so that it's there when the child becomes 21, and then the child can make his or her own decisions about what to do with it. So the court's most pressing interest is to make sure that the money's not lost, stolen, foolishly spent on things. What you're giving up is the potential for growth and interest and earnings on all those.
So you're saying everyone listening and watching
Yes.
who has listed in their will and or their anything else, accounts,
Right.
let's say, that any minors,
Right.
they list their children and then they list their grandchildren or contingent beneficiaries or however they do it. This is going to be imposed. If they're under 18, forget about them still holding the asset. The courts will override that and force them to convert in cash.
And now what I said at the beginning is that this is county by county. The judges within the county have the ability to enforce this requirement as they see fit.
Okay.
In Allegheny County, most of the time, the judges enforce it.
Wow.
Not always, and sometimes if it's a small amount of money, if somebody says, oh, I'm going to give my grandchildren $1,000,
Right.
the judge may let it go, but they're not required to. They have the option at all times to force these sequestered accounts.
So what do all the families do that are listening and watching? 35-year-old married couple bought a house, have 2 children at home, and they decide that they want all of their assets to go to each other first. A spouse, let's say, would be a common selection.
Right, exactly.
And then a contingent would be to the children.
Right.
And the children are, of course, minor in that situation. And something happens to both spouses in a car accident, for example. What's the alternative so that the assets can get to the minors in a form that the parents really did want?
So what I encourage people to do is use something that we call a testamentary trust. So what you have is your regular will, and it includes a trust inside of the will. And the trust becomes effective only upon the death of the person who created the will, and if the beneficiaries are under whatever age they specify. So at a minimum, it would be 18, because that's the age of majority in Pennsylvania. Okay. Sometimes people want it to be 21, 25, 30, whatever age. You can specify an older age, but at a minimum, the age is 18. So if the parents die and if the children are under 18, then this trust, it springs into action, and it becomes an effective trust at that time, at the death of the parents. And under the terms of the trust, the parents have designated who's going to serve as the trustee. So it might be their siblings, or it could be the parents, essentially the grandparents of the children, or it could be their best friend or whoever, but they've named somebody that they want to serve as trustee. The trustee then has 100% control over the assets for the benefit of the children. So the terms of the trust would specify that, when the children get to be 25 and 30 and 35, the trustee is going to pay out some of this assets to the children.
Okay.
In the meantime, the trustee will manage the account and use the money for the interests of the children. So if the children need to go to the doctor and they need to pay for it, if they need medicine, if they need school supplies, if they need clothes for school, the trustee can use that money and pay for those things for the children.
Okay.
So that's really the best solution, is that the parents have selected somebody that they feel comfortable with and that they believe would act knowledgeably, because you're going to deal with the financial affairs of somebody else,
Right.
and implement the best wishes of the children, the minor children, until they get to be whatever age the parents want them to inherit the assets.
So walking down this checklist, the parents get to guardianship and they say, okay, we're finished.
But
They
you're not
didn't
really
go far
finished.
enough.
Right, you're not
Okay.
really finished. Because the guardianship in your will is who has physical control over the children.
Right.
They're going to live with me. I'm going to make sure they get to school on time. I'm going to make sure that they're well fed and well clothed. That's what the guardian does.
Right.
Now, if you specifically list a guardian of the estate as opposed to a guardian of the person, that's where you get in control of their assets.
Okay, and who would know that?
Right. Most people don't know that there's a difference and that you need to have both.
Tammy, this is far too complex for people to do on their own. I can see this clearly.
Right.
I hope all of you watching and listening can now see how obvious it is. Yes, you can go online and do an immediate will and very inexpensively, but you could see by even just this show how much you would be getting, what you're paying for, and how much you're missing. Tammy, I have to wrap up the show because of time. How do people best get a hold of you if they want to come in for a consultation and inquire on their own personal situations?
Well, my office is right across from South Hills Village, so we're right in the area. And our phone number is 412-851-0529. We also have a website. It's www.singletonenglishlaw.com. And I would recommend that people call and schedule an appointment, and we will sit down and go over what your personal situation is, and I would give you some suggestions on what I recommend you do, and then it's up to you which things you choose to implement and which things not. But I do like to talk to people face to face and gather some information and see what would be appropriate for that particular situation.
Okay. Well, thank you again for being
Sure.
on the show.
Great.
Thanks
Glad to be
again,
here.
everyone, for tuning into another edition of All Things Financial. We'll be back again next week.
Securities and investment advisory services offered through SagePoint Financial Inc., member FINRA SIPC, and registered investment advisor. Insurance services offered through Driscoll Insurance and Financial Services Inc., which is not affiliated with SagePoint Financial Inc.